Good morning and good afternoon. Good morning in Costa Rica and good afternoon in Zambia. My name is Aurélien Laurent from the CRC Foundation, and today we'll have a match between two teams who qualified from the 8th of finals. Now we are in the quarterfinals of the Inter-University Law Debate Tournament 2025 8th edition. We have a team from the University of Lusaka in Zambia, and we have a team from ULACIT, Latin American University of Science and Technology in Costa Rica. So it's a pleasure for me to have these two teams debating on a topic on this time a transboundary environmental harm as well, and we'll see what the students will provide on that topic, of course. But first, let's give them the floor for an introduction. So I give the floor first to Sizwani Mwale in Zambia. Welcome.
Thank you. My name is Zwani Mwale, a second-year law student here at the University of Lusaka, and I'm really excited to take part in this quarterfinal match. Thank you.
Thank you and welcome. We have as well in Costa Rica, Maria Carolina González Blanco. Welcome.
Hi everyone, I'm really excited. I'm Carolina González Blanco and I'm from ULACIT.
Thank you, welcome. We have as well in Lusaka, Mulima Kalwe. Bienvenue, welcome.
Hello everyone, I'm Mulima Kalwe, a third-year law student at the University of Lusaka, and I'm very happy to have made it this far, and I'm very excited for this match.
Thank you, welcome. And we have as well in San Jose, Mr. Gabriel David Jiménez Benavides. Welcome.
Hi, thank you. My name is Gabriel Jiménez Benavides. I just accomplished my first year here at ULACIT. I'm an international relations student, and thank you very much for the opportunity to be here again.
Thank you, welcome. And we have as well Mr. Mbulo Mwaba. Sorry.
Hello everyone, my name is Mwaba Mbulo. I'm a third-year student here at the University of Lusaka, and I'm happy to be here. Congratulations to everyone for making it this far.
Thank you very much. And finally, third member from the team in Costa Rica, Mabel Melissa Fernandez Ramos. Welcome.
Hello, thank you. My name is Mabel. I'm a second-year student of international relations here at ULACIT, and we're very excited to be here today. Thank you.
Thank you. Welcome. We send greetings as well to the coach. So the coach on the side, there are two coaches on the side of the University of Lusaka, Professor Teresa Lumbama Caputo and Miss Nicole Tanyeranzoa Boigna. And we send greetings as well to the two coaches on the side of ULACIT. So Professor David Jiménez Mendes and Dean José Armando Madrigal Segura. And I see that there is a post just now on YouTube from your coach. So thank you to all the coach we'll be watching. We've been preparing all this, I would say, for all this match, including this one. The topic which was sent to the two teams was states should be legally obligated to compensate for transboundary environmental harm caused within their territories. So now I will share my screen. So we'll see the randomizer on my screen. So normally you should see a wheel with the double flags and logos of your respective institutions. So there are two chances, one chance to be in favor and one chance to be against for each team. So the team will be in favor will be starting the match with the first introduction. So I'm starting now. For this match, the team will be in favor will be ULACIT, Latin American University of Science and Technology, and will be as well starting with the first introduction. As a consequence, the University of Lusaka will defend the position against the motion. Concretely, it means that ULACIT, Latin American University of Science and Technology, will defend the position that states should be legally obligated to compensate for transboundary environmental harm caused within their territories, while the University of Lusaka will defend the position that states should not be legally obligated to compensate for transboundary environmental harm caused within their territories. So now you will have 5 minutes to review your notes, and then we'll hear the introduction by the team from ULACIT. So we are done with the 5 minutes of preparation. So I stop sharing my screen. So before we start with the introduction, I remind that when you see the yellow card on my screen, it means you still have 30 seconds in your speaking time. You can continue to speak, of course. But when you will see the red card, it means that your time is over. I mean, your speaking time is over. You need to finish your sentence. Let's say if you start a new one, the judge might penalize for going over the time. So now I will give the floor for the introduction to the team from ULACIT. You have 4 minutes.
Thank you very much. I will be starting in 3, 2, 1. We live in a world where 99% of the global population breathes polluted air, where 3.6 billion people already face water crises, where the ocean acidification, heat waves, and biodiversity collapse threaten not only ecosystems, but economies, public health, and entire nations. This is not hypothetical, and without legal consequences, the destruction will continue. That is why we strongly affirm the motion that states should be legally obligated to compensate for transboundary environmental harm caused within their territories. This compensation is legally grounded, morally necessary, and strategically effective. Let's begin with some definitions. Transboundary environmental harm can be understood as significant damage that originates from one state and crosses into another or into global commons, causing harm. Compensation, whether financial or material, is a reparation owed by the responsible state, which in turn is the duty of a state to repair for the consequences of its internationally wrongful acts. Now, let's start with the layout of our arguments. First, legal foundation supports cooperation. Compensation is the next logical step in international environmental law. The Trails-Melcher arbitration case from 1941 ruled that no state may allow its territory to be used in a way that causes harm to another and ordered Canada to compensate monetarily to the US. The UNCLOS Article 194, Section 2 obligates states to prevent marine pollution that causes cross-border damage. The case of Costa Rica versus Nicaragua, the ICJ ordered Nicaragua to pay over $300,000 in environmental compensation. The ICO articles on state responsibility require full reparation, including compensation, for internationally wrongful acts. The ICJ's advisory opinion on the legality of nuclear weapons says, the environment is not an abstract, it is the health of human beings, including generations unborn. These are not radical ideas, they are the part of a corpus of international law. 2. Justice, and this is about justice and the victims deserve it. Too often, states that contribute the least to global degradation pay the highest price. Take small island developing nations, for example, which are being submerged by rising sea levels caused by emissions they did not produce. The Rio Principle 7 recognizes the common but differentiated responsibilities. Those who cause the harm, the greater harm, must bear the greater burden. The OECD polluter pays principle affirms that the responsible state must internalize costs. The UNGA of 2022 recognized the right to a healthy environment, and the Inter-American Court affirmed that the environment harm threatens life and human dignity. Even Costa Rica's constitution in Article 50 declares the right to a healthy environment, and we know that rights come with remedies. This includes the harm to global commons, the atmosphere, oceans, biodiversity. They are not owned by one state, yet they are damaged by many. And a compensation framework is the only way we can assign responsibility where governance is shared. 3. Compensation fosters prevention and cooperation. Compensation does not compete with prevention, it reinforces it. It sends a message. Harm has a cost. The Water Courses Prevention obliges states to compensate for significant harm, and the Basel Convention mandates liability for illegal waste trade. A regional example is the Danube Convention, which shows that legal frameworks improve cooperation. International law already says states cannot use or permit the use of their own territory to the detriment of the rights and the legitimate interests of other states. We face an era where climate change and ecological collapse are globalized, but accountability is not. That has to change. The tools exist, the law supports it, the victim deserves it, and the planet demands it. And it is time we hold states responsible for the harm that they are causing and the reparation they owe. Let the law reflect the urgency of our reality. Thank you.
Thank you very much. So now I give the floor to the team of the University of Lusaka for your introduction. You have as well 4 minutes.
Am I audible?
Yes, you are. You can start.
Okay, I will start in 3, 2, 1. Esteemed judges, respected propositions, ladies and gentlemen, good morning or good afternoon. We as the opposition stand firm with the motion that states no state should be legally obligated to compensate for transboundary environmental harm. We as the opposition don't deny the seriousness of transboundary environmental harm, but we recognize that a legal obligation is flawed in practice and outcome. And here is how. Our speech will focus on how prevention is more effective than compensation, proving harm is significant and legally complex, and our solution. Now, let's get into our first point. Prevention is more effective than compensation. In the Charles Murter case, the International Court of Justice established the preventative principle, which states that states must stop harm if it affects the environment, not looking towards compensation. It noticed that we cannot bring back things that have been lost due to environmental degradation. Therefore, it is important to prevent harm before it escalates. What does the preventative principle mean? We must stop harm before it goes. Therefore, enforcing a legal obligation to ensure that compensation is done will make powerful states think that the environment is a paycheck. How much will you pay to continue to pollute the environment just so you can continue to benefit from it without giving back? We need to remember that environmental damage is normally and most of the time irreversible. The environment cannot go back to a state it was when damage occurs. Therefore, we are advocating for prevention. Why must we only care about the environment when harm occurs? Therefore, we strongly support the preventative principle that we must not continue to do harm to the environment just because someone can afford to pay for it. Secondly, proving harm is significant is more scientifically and legally hard to establish. How? Let's take, for example, the Charles Murter case. Arbitration took more than 6 years to establish, and what was happening to our environment? The environment was being degraded because people were trying to find who to blame just so that the environment can be fixed. We stand in opposition of this motion because we don't want a blanket obligation that's going to be pointing blame to states. We want states to cooperate together and work in harmony. Take, for example, what happens in China. China is polluting the environment and is affecting South Korea and Japan through acidic rains. But because they continue to do so, they don't want to treat the environment as something that we must protect first rather than considering as a paycheck. Therefore, we as the opposition stand firm in favor of the motion, opposing this motion that states we should not compensate. We need to treat the environment as something that must be protected first before we can compensate, because compensation is not the solution to helping the environment. So, what is the solution? International law does not have a global enforcement mechanism like domestic law. Domestic law is used by the police or the courts, but it does not have that in international law. Therefore, a solution that is going to help everyone is what we are advocating for. For example, in the Pop Mills case, the International Court of Justice stated that we must work towards cooperation and trust, because cooperation, communication, and trust is going to ensure that states work together to prevent harm and so that they can be sovereign together while developing their states. A legal obligation is going to erode trust because states are going to be blaming each other for who is responsible for the environmental damage. Therefore, we as the opposing delegation strongly oppose to the motion that states must legally compensate for environmental damage. With these few points, I rest my case.
Thank you very much. So now we are moving to the first rebuttals. I give the floor to the team of ULACIT, Latin American University of Science and Technology, for your first rebuttal. You have 2 minutes.
Thank you. I will start in 3, 2, 1. We as the proposing team believe that today's opposition is attempting to downplay one of the most fundamental principles of international environmental law: state responsibility for cross-border harm. Let's begin with prevention, a word they seem to love. Prevention is not an excuse for impunity. Prevention, as defined in modern international law, includes responsibility. Prevention is not licensed to pollute. According to Principle 21 of the Stockholm Declaration and Principle 2 of the Real Declaration, states may exploit their resources only if they avoid causing environmental damage to others. They argue that enforcing this is complex, but complexity is not an excuse for inaction. Cases like the trail smelter between Canada and the US, pulp mills between Argentina and Uruguay, and Gapsico Najimaros between Hungary and Slovakia, and already confirmed that states must prevent cross-border harm. And when they don't, they should be held accountable. What's missing is consequences. Compensation is the step to make these duties real and enforceable. On causation, they might claim that it's hard to prove, but international law accepts the precautionary principle, which allows action even without full scientific certainty, especially when due diligence is lacking. And on cooperation, let's be honest, is this vague goodwill more effective than real responsibility? Compensation promotes justice, creates deterrence, and strengthens prevention. In 2022, according to estimates of the World Bank and the United Nations Environment Program, transboundary pollution from wildfires and mining caused damages exceeding $14 billion in South America and Southeast Asia. Should affected nations bear the cost? Thank you.
Thank you very much. So now we hear as well the first rebuttal from the side of the University of Lusaka. You have as well 2 minutes.
Am I audible?
Yes, you are.
All right, I'll begin in 3, 2, 1. Now, ladies and gentlemen, it should be understood that transboundary harm is very important, and we should look at it in the environment. However, what we should look at also is that the proposing delegation has not given us any solutions. They've given us with a lot of authority and a lot of statutes, but they haven't given us how exactly they're going to implement these things. Now, that's why as the opposition delegation, we are saying that the prevention is better than the cure, because the cure that the proposition delegation is bringing doesn't even have any structure, it doesn't have any flow. So we as the opposing delegation are here to say that the prevention of this is the best way that we should go with. As my previous speaker had stated, environmental damage sometimes is very difficult to rectify, and sometimes it's irreversible. As such, should we now look towards to providing compensation in order for us to prevent, in order for us to lessen the burden that's on that victim, or should we look at preventing the harm in the first place? Also, the proposing delegation has not even told us how exactly this compensation should come about. They haven't told us whether this is going to be monetary compensation or this is going to be compensation by ways of actions. As such, I don't think the proposing delegation has brought enough points to convince us that we should actually allow this motion. Now, as the opposing delegation, we are here to say that the enforcement of this, of allowing the motion is going to be very vague. Because honestly speaking, if we look at the motion, we are saying that there should be the legal obligation on the states. And of course, we understand that it's important for them to be obliged to do this. But however, as we've seen in the past, states are reluctant to look at issues like this. As was stated by my previous speaker, states would look at this as an economic issue. They'll look at issues of environmental degradation just as an Excel spreadsheet. They'll look at how they can cut costs and actually pay for those reparations instead of looking at upholding the environmental integrity. That's why we as the opposing delegation are here to say that the likelihood of success of allowing the motion is going to be very low, because previously, as we've seen, states are reluctant to look towards the cooperation and to prevent this transboundary environmental harm. As such, we oppose this motion. With those few points, I rest my case.
Thank you very much. So now we are moving to second rebuttals. I give the floor to ULACIT, Latin American University of Science and Technology. You have 2 minutes.
Thank you. I will start in 3, 2, 1. Colleagues, we are not proposing a radical disruption. We are recognizing the next legal step in the evolution of environmental law. The ICJ has already established the foundation. In the 2010 pulp mills case, Argentina versus Uruguay, the court confirmed that states have procedural obligations when their domestic activities may cause transboundary environmental harm. And the ruling in the Costa Rica versus Nicaragua case was even clearer. Damage to the environment and the consequent impairment or loss of the ability of the environment to provide goods and services is compensable under international law. That includes compensation before full recovery and the cost of environmental restoration. This motion is not just about legal theory, it is about accountability. Victims and affected nations should not bear the costs of the destruction that they did not cause. For example, in the case of the 1999 Bayamine cyanide spill from Romania, affected Hungary and Serbia's ecosystems, causing millions of dollars in damage to fisheries and even drinking water, which affected downstream communities to continue absorbing the long-term costs of this situation. The United Nations General Assembly recognized in 2022 that everyone has right to a clean, healthy, and sustainable environment based on the Universal Declaration of Human Rights, making environmental protection a fundamental human rights obligation. Another example is Costa Rica's constitutional Article 50, which affirms that everyone has the right to a healthy and ecologically balanced environment, and it explicitly recognizes the state's duty to guarantee, defend, and preserve it. Finally, this is also about intergenerational justice, because if we allow states to destroy ecosystems beyond their borders without consequence, we are violating not only the rights of our neighbors, but of the future generations also. So let's be clear. International law already recognizes transboundary harm and the right to a healthy environment. This motion does not invent obligation, it reinforces it. Because without legal compensation, environmental justice remains incomplete and the law continues to be unenforced. Thank you.
Thank you very much. Now we hear the second rebuttal on the side of the University of Lusaka. You have 2 minutes.
Am I audible?
Yes, you are.
I'll be starting in 1, 2, 3. As had been mentioned in the by the proposing side's first speaker, these issues are indeed fundamental, and we completely agree with that. However, as she had mentioned, multiple of these issues happen to be cumulative, which is why we argue that the placing of legal obligations upon states is simply impractical. Because when you look towards environmental harm, it is rarely clear-cut and defined. The cases that they had made reference to had made reference to the fact that when it comes to compensation, you have to prove this environmental harm. We cannot expect states to fall in line with legal obligations placed upon them when it comes to speculative attribution of liability. States prefer something that is predictable and something that they can actively fall in line with. They will not be expected to fall in line with they will not be expected to agree with something that does not have any clear and cut definition. As they had previously mentioned, there's been no properly set form of compensation, and their solutions happen to not have anything that states can actively agree to because it has not been clearly defined. We are not trying to suggest something that is radical. We're trying to suggest that we do agree with these fundamental principles, but that we're looking at this realistically. We look towards the fact that the Chell smelter arbitration, despite having been set quite a while ago, has not actively affected the status quo that states fall in line with. That being that states are not willing to actually pay reparations or compensation when it comes to environmental harm. And that is what we're trying to state. When we look towards these legal obligations, this relies on actual voluntary consent from states. We look towards Article 34 of the Vienna Convention on the Law of Treaties, which provides that a third party cannot be bound to cannot have obligations placed upon them when it comes to agreements and treaties that they actively do not agree to. We look towards the current status quo, despite the instances of the Chell smelter case. What then will we expect from them when it comes to legal obligations placed upon them? They will simply be reluctant, and therefore the proposing side's motion simply cannot succeed, which is why our motion can succeed. As our first speaker had mentioned, we look towards domestic and regional solutions rather than an international solution that holds no weight. With that, I rest my case. Thank you.
Thank you very much. So now we are moving to the conclusions. I give the floor to the team from ULACIT in American University of Science and Technology. You have 2 minutes.
Thank you. I will be starting in 3, 2, 1. Honorable judges, the opposition wants you to believe that legal obligation is flawed because environmental damage is hard to prove and irreversible. But that is exactly why we need compensation. When prevention fails, as it often does, victims deserve more than thoughts and prayers. They deserve repair. They deserve justice. The claim that compensation is impractical, but international law already does this. In Costa Rica versus Nicaragua case, the ICJ calculated environmental damage and awarded compensation. The Trail Smelter case proved cross-border pollution that can be quantified. The Watercourses Convention and the Basel Convention show how states can negotiate and implement compensation frameworks treaty by treaty, case by case. We never said compensation replaces prevention. It complements it. Legal obligation makes prevention stronger because when polluters know they will be held accountable, they are much more likely to act early. They argue we offer no structure, but the structure is already emerging. Compensation calculated through environmental impact assessment exists, distributed via existing courts like the ICJ, or new bodies modeled after the Loss and Damage Fund adopted by the COP of 27, built on principles like the CBDR, ensuring fairness and equity. Finally, they say compensation would make countries see the environment as a paycheck. But what we're proposing is not payment for pollution, it's accountability for harm. Let's be clear, nothing is meaningful without remedy, and no prevention is effective without consequences. We are responsible for the protection of our environment and to hold accountable those that are harming it actively and getting away with it like it's not harming the rest of the world. Global commons are shared resources governed by all, and we need to start putting statutes that actually make these states responsible for the actions that are harming our planet and the generations to come. Thank you.
Thank you very much. So now we hear as well the conclusion on the side of the team of the University of Lusaka. You have 2 minutes.
Right, I'll begin in 3, 2, 1. Ladies and gentlemen, the debate that we have today is a debate that seeks to find a solution to the issue that we've had concerning transboundary environmental harm. Now, the proposing delegation hasn't given us any ways this solution is going to be implemented. We understand and we acknowledge that they've given us a lot of statutes, a lot of provisions that show principles in which transboundary environmental harm is enshrined. However, they haven't given us any effective ways in which they're going to actually implement this if we do allow the motion. That's why we are strongly opposing this motion, because we see that it is effective for us to look for other remedies other than for us to legally obligate states to pay. Now, ladies and gentlemen, we understand that it is important, but again, the main question is it effective? We need to look towards effective measures. We're going to make sure that the environmental integrity is upheld, and we're not just going to look at ways in which we're going to look at the economics of the situation. Also, ladies and gentlemen, we need to understand that when you look at the Troll Smelter case, the principle of that case is we're looking towards prevention of the issue, and we're not looking towards the reparation or the compensation of the harm. As such, ladies and gentlemen, it is imperative that we should look at the prevention of the harm at the root level, other than looking at us trying to prevent the harm, trying to remedy the harm after it has happened. As my previous speaker had stated, it is very unlikely that once we allow this motion, it's even going to be effective, because as has been seen, the Troll Smelter case, being the landmark case dealing with environmental harm, is an arbitration case, meaning it only existed because of a bilateral agreement. We haven't seen any issues that occur outside this case, which signifies any legal obligation. As such, it is not conclusive that it's going to be effective and that this legal implication is really going to solve the issue that is at hand. That is why we as the opposing delegation are here to say that the legal implications and obligation is not going to solve the issue that is at hand, and we strongly oppose this motion. With those few points, we rest our case. Thank you.
Thank you very much. So we just heard the 2 conclusions, so it means from now you are not under evaluation by the judge. So you can rest, you can take a breath, and as well on the side of the Corax Foundation, many thanks for this very intense debate of quarterfinals. Of course, that shows indeed these are 2 teams among the 8 best teams of this competition for this year. So congratulations to all the participants for this match. And we hope as well the free judge, and we thank the free judge, will have time to watch and rewatch the match during the next days. So I hope they enjoyed as well as much as I did. And now it is time to collect your impression on this match, of course, on the topic as well, performance of the 2 teams, and the preparation in general. So how was it in Minsk? So I will start with Miss Mabel Melissa Fernandez Ramos. What do you think about the match?
Thank you. Well, it was very rich, I think. I really enjoyed engaging in this debate. We admire the Lusaka team quite a lot. We have been seeing their past debates, and we were very excited to engage in debate with them because of how active it would be. And it definitely paid off. So it was very, very much one of the best debates we've had so far, I think.
Thank you very much. Miss Mbulo Mwaba, what do you think about the match?
I think it was a really fun debate. It was very heated, listening to the back and forth, back and forth. I think both sides really understood the motion and we both knew what we were talking about, which made it fun and engaging because it's really fun when a debate is engaging and like where you're just stating your points. But because we kept going back and forth, it showed that we all knew what we were saying and we understood it and we were all ready for each side of the debate. So it was really great.
Thank you. Mr. Gabriel David Jimenez Benavides, what do you think about the match?
Yeah, I think, again, it was pretty great. It was, as my classmate mentioned, it was a very rich debate. We tried to prepare the best we could for this. As, again, my classmate mentioned, it was an honor to have this match against the current champions of the tournament, which is the Lusaka team. We tried to study them. We tried to see if we could see like any weakness that we could use in our favor. And yeah, it was pretty good actually.
Thank you very much. Now, same question for Miss Mulima Kaloué. What do you think about the match?
The match was really intense, and I enjoyed the fact that you could clearly tell that both sides, the proposers and the opposers, felt very strongly about the environment and environmental law. So you could tell that these are clearly people who care about what they were arguing about and that we all actively loved the motion as well. So I really did enjoy debating against you guys.
Thank you. Same question, Miss Maria Carolina Gonzalez Blanco.
Yeah, thank you. I think, as my classmates have also said, it was definitely an enriching debate because actually using all the preparation that we've done and seeing as a really interactive debate when we were both sides were really prepared, I think it was really the best debate we've had, definitely.
Thank you very much. Mr. Sizwani Mwale.
Yeah, I think as my colleagues have said, this was a really intense debate match. I think also considering the high stakes that are there for this match, it was really, I think, in my opinion, the best debate match that we've had. And I really want to commend our opponents that they really brought their A game today. And it was really good and really fun to debate against you guys. Thank you. Thank you very much. So yes, that was, as you said, a lot of energy, a lot of intense content, and as well very, very good on the both sides to listen to the argumentation on both sides. So congratulations again, and we hope, of course, that the judge will take the time as well to assess carefully all the elements. I would not like to be judge of that match, to be too difficult, in my opinion. But anyway, so congrats again, and now it is time to do a bit of networking. So the two questions will be focusing on your future, each student, what you want to achieve, what you want to do, and as well where maybe you would like as well to study if you have an opportunity to go to another country. So I will start with asking, for example, Mr. Siswani Mwale, if you have a personal or professional dream in your career, what would it be during the next 2 years, let's say? Okay, so for me, ultimately, I just want to be a practicing lawyer. That's why I'm in the law school, of course. And then also I would like to branch into alternative dispute resolution. I think arbitration, reconciliation, and all those aspects of alternative dispute resolution are so interesting to me. So I would like to be in the legal faculty and then also delve into alternative dispute resolution in the future.
Okay, ADR. Okay, thank you very much. Miss Maria Carolina Gonzalez Blanco.
Hi. So I am actually studying international relations. So I think I would, the area that I am really interested in and would like to pursue would be international cooperation. I would definitely want to continue searching more in that framework, in that area, because I really like the idea of helping communities and different also comparatives and small countries to continue with their process. Thank you.
Thank you very much. Ms. Mulima Kaloué?
In terms of my dreams, mine are quite personal. because my mom herself is a lawyer and my older sister just recently passed our bar exam. So for me personally, I want to follow in their footsteps and just kind of keep it in the family and show them that law is something that I'm very passionate about. And I hope that I can make them both proud because they do make me proud as well. So I hope to just stick to law and stay confident in it as well. So yeah.
Thank you. Mr. Gabriel David Jimenez Benavides.
Sure. Okay, I mean, I think we all are studying international relations. Well, I think no, it's the reality. We all are studying international relations. I don't know. I think this is a career where you can do a lot, actually. You can go with diplomacy, you can work with the United Nations, we can do a lot of things. Personally, I haven't decided yet, but I think I would like to go within public service. I don't know. I think I want to serve my country. I think I want to work for my country. Well, I don't know. Maybe I'm quite patriotic in that sense, but yeah.
Thank you very much. Yes? No, I thought you wanted to add something. Yes, Miss Mbolo Mwaba.
So for me, my personal goals are starting organizations that support children. Like for here in Zambia, our legal system is a dual legal system. We have the traditional side and we have the common law side. So for me, most of the time, like when the semester ends, I would go to the farm and educate young children in rural areas and just tell them about their rights, how they can learn. And when I also hear matters concerning traditional letters that are against the law, I would go there and write a letter and tell them that they're not supposed to do that so that I can protect the children and can ensure that our community develops. For my future, I have a lot of goals. I don't have one particular side, but because I'm also at the farm and I like farming a lot, I think I would like to focus on environmental law because our country is now coming up with like acts, the Climate Change Act. We also have an act that talks about environmental impact assessments. So I think if I have an organization there and I'm farming there and I'm learning environmental law there, then everything is going to fall together into place and it won't stress me out a lot. It's just going to work perfectly. So those are my goals.
Thank you very much. And Miss Mabel Melissa Fernandez Ramos.
Thank you. Well, for me, definitely, I would like to explore the intersection of international relations and law. That's kind of what calls my attention the most. So not necessarily just international law. There's other aspects that are more related to domestic law, but still touch upon some international policies. So for me, that's kind of like where I see myself headed.
Okay, perfect. Thank you. Thank you very much. So that was the session of the quarterfinals. So many thanks to both teams for your preparation and as well, this is not just a match, it is actually the 5th match already on both sides. So congratulations for reaching that level. 5th out of 7, we hope, of course, we'll have a 7 match. It means that you will be in final in the next 2 weeks. So congratulations again from here in The Hague. It was great to see how much you were into environmental law as well on that topic. And we'll send you the results very soon and then publish it online on the platforms. So congratulations on both sides. We keep in touch and we'll see you, I hope, in the semi-final very soon. Many thanks again and we keep in touch. Bye-bye. Bye-bye.